Welcome, curious minds, to another deep dive. Today, we're navigating some pretty important but maybe overlooked waters of agreements, especially in Islamic finance. We're zeroing in on incidental events affecting obligations. That's Sharia standard number 36. Our mission, really, is to unpack what these unexpected things are, how they can change or sometimes even completely end an agreement, and why understanding this is just vital for anyone dealing with financial obligations, especially with Islamic financial institutions. It's sort of about building contracts that can, well, bend without breaking.
Exactly. And what's really fascinating, I think, is how this standard gives us a solid framework. It's for dealing with things you just couldn't see coming, specifically in financing and investment. It's less about just reacting and more about building in resilience,
Yeah.
getting clarity before the unexpected hits.
Precisely. So we're focusing on how these events affect obligations within those specific Islamic finance structures. And maybe just as importantly, we need to be clear what the standard doesn't cover, like defects of will, things that were wrong right when the contract was signed.
Right, those are issues present at formation, even if they only surface later. This standard isn't about that.
Okay. And it's also not about just, both sides agreeing to call it quits.
Correct. This is about external factors coming into play after everything's signed and sealed.
Okay, so where should we start?
Well, we often hear force majeure in other contexts, but Sharia Standard 76 talks about these incidental events affecting obligations. How is that concept maybe broader or different, and really nailing down how they differ from a mistake made during the signing? That seems key.
That's a great point, and the standard is quite precise here. Basically, incidental events are things that impact the agreement or the duties arising from it after it's been properly made. They're external things influencing the contract after signing.
Okay, so post-signing.
Oh.
External, yes. And that's a core difference from defects of will. Those defects are issues baked in at formation. Maybe you didn't know, but the flaw was there from the start. Think of it like a building with a shaky foundation that's a defect of will. An incidental event is more like a sudden earthquake hitting a well-built structure.
That's a really helpful analogy. Foundation flaw versus external earthquake. Got it. So timing and source are critical after signing and from outside the party's initial agreement or flaws.
Exactly right. And they're also distinct from just ending things by mutual consent or one party using a right they already had to withdraw. It's always about these, well, uninvited external factors.
Okay, so if these events happen, do they always just blow up the whole contract, or can things be adjusted?
That leads us perfectly into the first main category, modifying incidental events.
Right, the ones that tweak things rather than end them.
Precisely. So we accept contracts aren't totally static. How does Standard 36 allow for adjustments fairly? What are some common examples?
Yeah, what kind of real-world situations trigger these modifications?
Okay, so these events adjust responsibilities, but the core agreement often survives. It's about finding a fair path forward. Take customs duties or taxes. Imagine you sign a deal maybe to import something, and after you've signed, the government imposes a brand new customs duty or tax.
Oh, okay. That could sting.
Right. The standard helps clarify who shoulders that new cost. It might be dictated by the new law itself, or perhaps the contract anticipated this and already assigned responsibility.
So it prevents one side getting unfairly hit with a surprise cost.
Exactly. Or think about changes in raw material prices. Say a contractor agrees to build something for a fixed price.
Yeah, standard practice.
But then, maybe due to some global event, the price of essential steel or cement just skyrockets, unforeseeably. If this causes significant, genuine harm to the contractor, the obligation can be modified. The standard aims to remove the actual harm suffered by the one doing the work.
How? Does the price just get automatically adjusted?
Not automatically. It might need reconciliation between the parties, maybe formal arbitration, or even a court decision. The goal is fairness, relieving that unexpected burden.
Okay, makes sense. What else?
How about import bans? Let's say a company is contracted to deliver specific goods. This could be a simple sale or part of an Islamic finance deal like Murabaha, where the bank buys and resells the goods, or Ijara, leasing.
Right.
And suddenly, the government bans the import of those exact goods.
Oh, wow. So performance becomes impossible, at least temporarily.
It certainly causes harm. The standard provides for removing the actual harm suffered by either the client or the financial institution, again, through negotiation, arbitration, or legal ruling.
So it's about mitigating the damage from that external shock.
Precisely. And one more. Changes in laws, increasing financial obligations. Similar idea. If a new law comes in after the contract is signed and it significantly increases the cost for one party to fulfill their side of the bargain.
Like new environmental regulations needing expensive upgrades.
Could be, yeah. The standard says that increase is borne by whoever the law itself designates, or whoever the contract stipulated would cover such changes.
So the big takeaway here seems to be that Shari'ah Standard 36 builds in this kind of proactive resilience. It's not just about what happens if someone defaults, but how the agreement itself adapts to a changing world. It feels quite dynamic.
It is. It reflects a principle of fairness, adl and isam, adapting to unforeseen difficulties rather than sticking rigidly to terms that have become unjust due to external events.
Okay, that covers the modifications. Now let's pivot to the more dramatic outcomes. Terminating incidental events. These are the big ones, right? Where the obligation actually ends because of something external, something neither party caused.
That's right. These are events that essentially make the contract impossible or pointless to continue. The consequences generally fall on the obligor, the one supposed to perform, unless the contract says otherwise.
So what kind of external events are powerful enough to completely nullify an obligation?
Well, the first major one is impossibility of performance or futility. This means that the obligation just ends. If fulfilling, it becomes genuinely impossible or completely pointless.
But there must be conditions, right? It can't just be, oh, this is hard now.
Absolutely. The conditions are strict. First, the impossibility must be absolute, like truly insurmountable, not just difficult or expensive.
Okay.
Second, it has to stem from objective reasons. Not just, I personally can't do this anymore, but nobody could do this under these circumstances.
Objective, not subjective inability. Got it.
And third, crucially, the source must be external to the obligor. Something entirely beyond their control, a natural disaster, a new binding law making it illegal, that sort of thing.
So it's a high bar.
It is. Then there's the destruction of the subject of obligation. This is pretty straightforward. The specific thing the contract is about gets destroyed, maybe fully or even partially.
Like the actual car being leased gets totaled.
Exactly. Now, who bears the loss depends on the timing and cause. If it's destroyed before it's delivered to the obligee, the one receiving it, and it was still technically under the obligors, the providers, guarantee your responsibility, the obligation ends. The provider can't deliver what doesn't exist.
Okay. What if the person receiving it somehow destroys it?
Well, if it's destroyed entirely by the obligee's action, then the risk, the guarantee, shifts to them. They destroyed it, they bear the consequences.
Makes sense. And what about acts of God?
Right. If the subject matter is destroyed, partially or fully, while still with the obligor before delivery, but it's due to a true act of God, a celestial event, a natural disaster with absolutely no human fault involved, then the obligation also ends. The risk falls away in that specific scenario.
So the specific cause and timing are really critical there.
Very critical.
Now, you mentioned the subject matter being destroyed, but what if? What if the seller never really owned it properly in the first place?
That's another key terminating event. Entitlement of the subject of obligation. This happens if it turns out the thing being sold, leased, whatever, actually belongs to a third party. The seller didn't have the right to transact it.
Ooh, that sounds messy.
It can be. In that case, if payment was made, it generally has to be returned to the buyer, the person from whom the subject was effectively taken, because it wasn't the seller's to give.
And what if only part of it belongs to someone else? Like part of a piece of land?
Good question. If only a part is subject to this third-party entitlement, then that specific part of the contract becomes void. The obligee, the buyer, usually then gets a choice about whether to proceed with the remaining valid part, perhaps with a price adjustment, or cancel the whole thing.
Wow. That really emphasizes the importance of due diligence, doesn't it? Ensuring clear ownership before you even start.
Absolutely fundamental in Islamic finance. It's about the integrity of the asset itself. Huge for risk management.
Definitely. Okay, what other terminating events are there?
Then we have rescission due to excuses. In Arabic, it's fasq liladar, annulment for valid excuses.
Excuses, like what?
This often comes up in leasing, in ijara contracts. Imagine something really unusual happens that causes significant harm. Something totally unforeseen and not part of the normal risks of the contract.
Like the leased property becoming unusable due to a sudden, unexpected event not covered elsewhere.
Exactly. If the harm is severe and the excuse is clear and apparent, the party suffering the harm might have the right to rescind, to cancel the lease.
Does it have to go to court?
It might be resolved by agreement if the excuse is obvious. But if there's a dispute, or if the situation is complex, then yes, it would likely need a judicial ruling to confirm the validity of the excuse and the right to rescind.
Okay. And one last category. You mentioned large-scale events.
Yes, calamities, or jawai in Arabic.
How are these different from just impossibility or destruction?
Calamities are defined as things that just cannot be prevented. Even if you knew they might happen, you couldn't stop them. Think widespread floods, droughts, maybe locust swarms. Crucially, though, it excludes criminal acts by humans.
So, natural or unavoidable large-scale disasters, not man-made malice.
Correct. The classic example is in agriculture. Say you agree to buy a farmer's upcoming fruit harvest.
Sure.
If a blight, a calamity, hits those specific crops before harvest, significantly damaging them, the price paid by the buyer is typically reduced proportionally to the damage suffered.
So the buyer doesn't pay the full price for damaged goods due to this external calamity.
Exactly. Or in leasing, in IJAR context, a widespread calamity might lead to waiving any portion of the rent that exceeds the sort of normal market rate during that period of hardship caused by the calamity. It's about equitable relief.
So for you, the listener, the key insight here is recognizing that some things are truly beyond anyone's control or even reasonable foresight. And this standard provides a mechanism, a path towards fairness, when those unavoidable large-scale events disrupt everything. It avoids rigid adherence to terms that have become impossible or deeply unjust.
Precisely. It's about shared burden in truly exceptional circumstances.
Wow. Okay, that was quite a journey through Standard 36, these incidental events. We've gone from defining these unexpected twists, figuring out how they differ from initial flaws, to understanding how they can either, modify an agreement, tweak it, or sometimes completely terminate it, all within this really nuanced Islamic finance framework.
It really does underscore the core principles of fairness, adl, and justice in Islamic finance, doesn't it? It ensures agreements have a way to adapt when major unforeseen challenges arise, protecting everyone involved. It definitely encourages you to think critically about how robust, how adaptable any agreement you enter into really is.
It certainly does. This deep dive really hammered home that contracts aren't just static documents. They're, in a way, living things that exist in the real world and can be profoundly reshaped by external forces. It shows a legal system trying to balance commitment with, well, reality and equity.
Well put.
So here's something to ponder as we wrap up. When you look at any agreement you're part of or might enter into, beyond the obvious clauses, what unseen risks, what potential incidental events might lurk beneath the surface? And how could understanding these principles, this idea of modifying or terminating events based on fairness and external factors, help you anticipate the unexpected? How could it help you build more resilience into your commitments, whether they're in Islamic finance or really any area of life? Something to think about.